Welcome to Live 6 tonight. Can a state legally opt out of an international norm it helped block? The Persistent Objector Doctrine and AI governance? That's the subject of conversation tonight. Imagine a state that does not merely disagree with an emerging rule of international law. It objects formally, publicly, consistently before every relevant international forum across every relevant negotiation over more than a decade. Under international law, there is a doctrine that speaks directly to this scenario. A doctrine that has been part of the architecture of customary international law for over 70 years. Tonight's puzzle for each one of you. Does that doctrine give the objecting state a permanent legal exemption, even after the norm crystallizes and becomes binding on the rest of the international community? And does the answer change when the norm being objected to governs autonomous weapons systems? Hold that question. This presentation, yes, at the end of it, we resolve it like any other time. Before I go further, your gut ruling in the comments, live, right now. Should a powerful state be allowed to opt out of an international norm simply by objecting to it long enough and loudly enough? Yes or no? Good evening and welcome back to the AI Law, Global Security, AI Risks and Liability, our channel, and this live premiere series on the AI Law Daily, Thursdays to Sundays every week at 8 PM CST. I'm your host, Nupur Mitra, as you already know me, a techno-legal analyst and a lawyer by profession, and this is your premier live analysis at the intersection of artificial intelligence, international law, and the governance gaps, collisions between them. Over 5 consecutive evenings, we've built a precise architecture. Live 1, domestic eminent domain mobilized for AI infrastructure. Live 2, the world's first binding AI treaty, private sector coverage optional, national security exempt. Live 3, the EU AI Act, extraterritorial ambition exceeding enforcement reach. Live 4, the UN's global governance deficit, coordination without enforcement. Live 5, lethal autonomous weapons in the field, an accountability gap, 2 overwhelming UN votes, and no binding treaty. Tonight, we examine the legal doctrine that sits at the heart of why that last gap persists. The doctrine certain states may be invoking, whether they name it or not, to remain permanently outside an emerging norm of international governance, the Persistent Objector Doctrine. Let us build the legal architecture from first principles. Customary international law, as distinguished from treaty law, forms through 2 elements: widespread state practice and opinio juris, the belief that the practice is legally required. When both elements are present and a norm crystallizes, it binds all states, including those that never signed a treaty endorsing it. This is both the strength and the structural tension of customary international law. The Persistent Objector Doctrine, the POD, it provides a specific exception. As defined in the peer-reviewed literature, including the analysis published in the Chicago Journal of International Law in 2022 by Shelley Aviv Yini, a postdoctoral fellow at NYU School of Law and the University of Haifa, the doctrine provides that if a state persistently and consistently objects to a newly emerging norm of customary international law during the period of the formation of that norm, the objecting state is exempt from the customary norm in question once it has crystallized and for so long as the objection is maintained. That definition contains three operative requirements. First, the objection must be made during the formative stage, while the norm is still emerging before it crystallizes. A state cannot object after the norm is established and claim exemption retroactively. Second, the objection must be persistent, maintained continuously, not invoked selectively. Third, the objection must be consistent. It cannot be contradicted by the state's own behavior. A state that objects in negotiations but acts in conformity with the norm it opposes risks losing its status. The foundational case is the Anglo-Norwegian Fisheries case decided by the International Court of Justice in 1951. The ICJ found that Norway, by its consistent and long-standing objection to a particular rule governing the delimitation of territorial waters, had exempted itself from that rule even as it applied to other states. That case, over 70 years ago, established the architecture of the doctrine as it exists today. There is, however, one absolute limit. Yeni's analysis is explicit. The persistent objector doctrine does not apply to Cogens norms, preemptory norms of international law from which no derogation is permitted. The prohibition on genocide, the prohibition on torture, the prohibition on crimes against humanity. No state can object its way out of those. So now, let us bring this doctrine into direct contact with the facts we established in our last live session. Writing at the Lieber Institute at West Point in February 2025, legal scholars Benjamin Perrin and Masood Zamani synthesized the positions taken by member and observer states in the UN Secretary General's report on lethal autonomous weapons systems. The UN General Assembly First Committee and the CCW Group of Governmental Experts Working Papers of 2023 and 2024. Their analysis identified three distinct national positions. The first, traditionalists, states that assert existing international law is adequate and that no new binding instrument is required. The leading proponents documented in the UN Secretary General's report are the United States, Russia, and Israel. Russia's position, quoted directly, there are currently no convincing grounds for imposing any new limitations or restrictions on lethal autonomous weapons systems, or for updating or adapting international humanitarian law to address such weapons. The United States, also quoted directly, disputes the usefulness of the meaningful human control test, arguing there is not a fixed one-size-fits-all level of human judgment that should be applied to every context. The second, prohibitionists, states calling for a new treaty categorically banning the development, deployment, and uses of lethal autonomous weapon systems. Their central argument is that the absence of meaningful human control is an ethical and legal imperative, not a matter of state discretion. The third, dualists, states supporting a two-tier approach, prohibiting systems that cannot comply with IHL while regulating others. Among the documented proponents here, Austria, the Netherlands, Switzerland, Spain, Norway, France, Germany, Italy, Luxembourg. Now, here is the analytical question this series has been building toward. An emerging norm is taking shape through UN General Assembly resolutions, the CCW rolling text, the positions of the majority of states, that meaningful human control over autonomous targeting decisions is legally required. As Antonio Coco of the Lieber Institute wrote in August 2025, the GGE ruling text as of May 2025 already bans the use of systems whose effects their operators cannot anticipate or control to meet IHL requirements. And Perrin and Zamani note directly that one route for developing binding norms is through customary international law itself. If that norm is information and the evidence it supports the conclusion that it is, then the traditionalist states are not merely disagreeing with a proposed treaty, they are objecting formally, publicly, and consistently to an emerging norm of customary international law during its formative stage. The analytical question is precise. Are the United States, Russia, Israel, and such other countries, even India, through their documented and sustained positions, operating as persistent objectors within the meaning of the doctrine the ICJ established in 1951? This is not a settled legal conclusion, mind you. There is no court that has made that finding, but it is the question legal scholars are now beginning to ask. And a June 2026 article by Mujib Jimo in the Emory International Law Review argues directly that certain AI governance principles are already forming as customary international law, with implications for states that have not participated in treaty-based frameworks. But the doctrine has a wall, and it is important to name it precisely here. The Persistent Objector Doctrine does not apply to Cogens. Preemptory norms. No state can use persistent objection to exempt itself from prohibition on genocide, torture, or crimes against humanity, or other norms the international community recognizes as non-derogable. Yeni's analysis states this explicitly. POD status is unavailable against Cogens obligations. Now consider the implications for autonomous weapons. If, and this is a condition, not a conclusion, if a fully autonomous weapons system operating without meaningful human control were to select and engage targets in a manner that constitutes an indiscriminate attack on civilians or a crime against humanity, the Persistent Objector Doctrine would not shield the deploying state from accountability under Cogens. The accountability gap we identified in Live 5 before this does not disappear because a state has maintained persistent objection to a governance norm. State responsibility under Cogens is not opt-out. That is the limit of the doctrine, and it is the limit that matters most when autonomous systems are deployed in active conflict. Now, before I resolve this, the question at the center of this entire debate, of this live premiere as well, And I want your vote on this live. When it comes to AI weapons norms, which principle should win? What do you think? Comment 1 for no state should be above an emerging norm the majority accepts. Comment 2 for state consent is foundational. Objecting states can stay out. One word. Where do you land? I want to see. So now let's come back to tonight's puzzle. A state publicly and consistently objects to an emerging norm over a decade before every relevant forum. Does international law give it a permanent legal exemption? The answer, grounded in established doctrine, is conditionally yes. The Persistent Objector Doctrine is, in Yinni's words, undeniably part of the language of modern international law and firmly established in the orthodox doctrine on the sources of international law. If the three requirements are met, objection during formation, persistent maintenance, consistent behavior, a state can, in principle, remain outside a norm of customary international law even after it crystallizes and binds others. But the conditions are strict. Consistency is the hardest requirement. A state that objects in negotiations but acts in conformity with the norm in practice through its military doctrine, its operational procedures, its domestic law, risks losing its persistent objector status. And the doctrine has an absolute ceiling. It cannot shield any state from Cogens obligations. Applied to autonomous weapons, the analytical conclusion is not that traditionalist states are definitively exempt from an emerging norm of human control. It is that the question is now live, legally serious, and consequential. Because if customary international law is forming around meaningful human control and the evidence from UNGA votes, the CCW rolling text, and majority state practice supports that conclusion, then the doctrine designed to respect state sovereignty may also be the doctrine some states are using to delay, dilute, and ultimately evade the governance architecture the international community is trying to build. That is the precise tension at the heart of international AI governance in 2026. Tonight's takeaway is this: the Persistent Objector Doctrine is not a loophole. It is a principled recognition that state consent is foundational to the international legal order. States that object early, clearly, and consistently have a legitimate claim to remain outside norms they have not accepted. But it carries a structural consequence. As Perrin and Zamani wrote, even if a treaty on autonomous weapons does not achieve universal adoption, it would nonetheless reflect the view held by most states. And they point to the precedent of anti-personnel landmines and nuclear weapons treaties, both of which created binding obligations for their parties and normative pressure for non-parties even without universality. Treaties that are not universal still reshape state behavior, and Cogens, as always, admits no exceptions. Next, Live 7. we'll examine the Martens Clause, an 1899 provision of the laws of war embedded in the Hague Conventions and the Geneva Protocols that may offer the most ancient and most underused legal argument for governing autonomous weapons. Can a 19th century clause govern a 21st century algorithm? 8 o'clock Central. Be there, Live 7 next. If tonight added precision to how you think, do these 3 things. Subscribe to this channel, the AI Law, Global Security, AI Risks and Liability. Please feel free to follow me on my LinkedIn, Substack, Instagram, and please do subscribe to thoughtleadinnovate.com/newsletter, because this is my mailing list, and I, through this mailing list, can connect with you directly without any platform in between. See you again.